Thank you, Susan. I'm Deborah Speck-Karstens, and I'm going to start off today talking about charitable gaming, and then I'll turn it over to Stacy, and she will talk more about the social gaming piece of things. So we'll get started here. First question, is it gambling? If there's consideration, chance, and a prize, that is defined as gambling in Iowa. Under Iowa's broad illegal lottery statute, an activity can be illegal gambling if only one person provides consideration. And if it is gambling, it must be authorized under Iowa law to be legal. So gambling in Iowa is permitted under, social and charitable gaming specifically is permitted under Iowa Code Chapter 99B and Iowa Administrative Code 481, chapters 100, 102, and 103. The statute in particular is somewhat confusing. There's lots of cross-references, and so I would encourage people to read the statute and the rules, and of course, if there are questions, feel free to contact myself at DIA or any attorney practicing in the area. And today we're really just going to hit the highlights of things. This isn't a really in-depth review of things, so we're just kind of scratching the surface here. In order to conduct raffles, bingo, games of skill, and games of chance, you must be a qualified organization. Qualified organization is defined in 99B. It includes a nonprofit with an active membership of 12 or more that is not self-perpetuating. It can be a governmental agency, a PTO, a booster club or school, or it can include political candidates, parties, or non-party political organizations. But I would note here that PACs are not eligible for a gambling license. So there are several different types of licenses that qualified organizations can obtain. You see here on this slide the list, 14-day, 90-day, 180-day, 1 year, and 2 year. Are some of the licenses and the cost for each of those licenses. Each license has specific requirements or restrictions as far as the number of raffles that can happen per year, for example, or the number of bingo occasions that can happen per week or month. So I would advise folks to talk to the department to determine which license would really best meet the objectives of the qualified organization. There's also listed here a real property or large cash raffle. That is for merchandise valued over $100,000. There's no upper limit on that, or for cash over $100,000 but less than $200,000. And with that particular license, the organization also has to have a 1 or 2 year license. And I would say probably the most common license would be the 2-year qualified organization license. Just a quick word about bingo before we move on to raffles here. We're not really covering bingo today. It's kind of its own entity and could have its own CLE. Again, there's complex specific requirements for bingo as far as prize limits, posting requirements, cost to play, and those kind of things, and we're not going to have time to cover those today, but just wanted to at least touch on that. So raffles, raffles. The definition of a raffle is a lottery in which the participant buys a ticket for a chance to win a prize, and the winner is determined by a random method. The winner cannot be required to be present to win. A small raffle is defined as the aggregate value of all the prizes is $10,000 or less, where a large raffle is the aggregate value of all the prizes is more than $10,000. And I would note that only one large raffle per calendar year is allowed under the various licenses. Oops. So with the raffle, the license period has to cover the promotion of the raffle, the sales of the tickets, and the drawings. So that's something to keep in mind when you're determining what type of license to obtain. Raffle tickets cannot be mailed. That's a federal law. And raffle tickets must be paid for with cash only. No credit cards are permitted. And there must be a set ticket price that's equal for everyone. And I just wanted to mention briefly the University of Iowa example. This came up earlier this year. People might have seen it in the news. The university was, they had a promotion to give away a year's free tuition to 5 students that were picked from those who bought football season tickets. So the university actually had a raffle license, but this promotion encouraged students to buy their tickets online. And of course, that doesn't comply with the statute because raffle tickets have to be paid for with cash and not credit cards. In addition, all raffle tickets have to be the same price, and in this case the university gave students the option of spending $150 or $175 depending on the number of games in the package that they chose. So again, that wasn't in compliance with the law. And also it wasn't clear whether the participants would be required to be present at the football game where this drawing happened to win. And if that was the case, then that would be a violation of the gaming law. So what happened here is the university suspended their promotion and changed up the rules after some discussions with our office and the Attorney General's office. So they changed it to basically be a sweepstakes where entries could be made through purchase of football tickets, or just submitting a name and contact information without any purchase. So there was no purchase necessary to enter or to win. And then all students who entered, whether they purchased tickets or not, would have the same chance of winning. And the student did not need to be present at the drawing to win. So that's just an example of something that sort of came to our attention, to the department's attention, and we worked with them in conjunction with the AG's office to make sure that they were in compliance with the law. So games of skill and games of chance are something that are permitted with the various licenses. A game of skill, the player has to do something to determine the result. This would be like a ring toss or shooting baskets, things like that. Whereas a game of chance, the result is determined by chance. So there are limits on the prizes here. If it's a qualified organization that's promoting the game of skill or game of chance, the limit on the prizes is $1,000 of merchandise. And if it's a non-qualified organization, the limit there is $50 of merchandise. And with the non-qualified organization, that you're going to see at like state and county fairs, city celebrations, amusement parks, those types of places are where you'll find those games. The rules of the game must be posted, and generally these are carnival or fair games. You would think of seeing those at a carnival or fair. It does not include casino-style games. So then we're going to move on and talk about annual game nights. And there are 3 types of licenses, 3 types of organizations that can obtain a license for annual game night, and each of them have different limits based on what type of organization and license they're getting. The value of the prizes differs, and we'll go through that here in a minute, and the amount the participant can win or spend is different. So we'll start with the qualified organization, and this is the typical qualified organization as defined, as we talked about earlier. With the qualified organization annual game night license, they can charge no more than $250 per participant for an entrance fee, game participation fees, and wagers. Only merchandise prizes can be given, and the value of those cannot exceed $10,000. Gift cards can be used if they're redeemable for merchandise only and not for cash. Only one game night can be held per year with this license. Anyone may participate, and the entrance fee for the game night is taxable. So, and the Department of Revenue, Iowa Department of Revenue does audit those things, so just something to keep in mind there. With an eligible qualified organization, this is kind of a subgroup of the qualified organization. This includes specifically veterans groups or emergency services providers, EMS. So those are the only entities that can obtain this kind of annual game night license. With this one, no more than $250 per participant for the entrance fee, the game participation fees, and the wagers. In this case, cash may be awarded, cash prizes or merchandise prizes The total value of the prizes, no more than $10,000. The participant cannot win more than $5,000 in cash and merchandise. And this license only allows one game night per year, and anyone may participate. Then we have the non-qualified organization. And in this case, again, a license is required, and this would be where the participants and the sponsor have a bona fide social or employment relationship. An entrance fee or participation fee is not allowed in this case. The sponsor cannot receive any consideration. There's no restrictions or limits on prizes and no reports required. And again, this is only one game night per year. Schools I wanted to mention, and this is typically your kind of after prom party. I think you see this happening where there's an annual game night. And this, in the case of schools, they're actually exempt from licensure, so they don't need to get a license at all if these things are requirements are met. So the game night has to be approved by the school board. Only students may participate. There's no participation fees allowed, and you can use just play money. There's no restrictions or limits on the prizes, and no reports to the department are required. There's no restriction on the frequency of the game nights either. So the game night, the annual game night, can include games of skill, games of chance, and card games. Those are allowed. Slot machines are not allowed, and social gambling is not allowed. The game night cannot last more than 16 consecutive hours, and it must be held at the location that is on the application for the license. So just some general rules about charitable gaming that apply across the board generally. No person can receive any profit, remuneration, or compensation from the games except any prize. So any amount that can be won on the same basis as other participants. The persons conducting the game or raffle cannot participate. The ticket prices have to be the same for all participants. And again, only cash can be used to purchase tickets and participate. And that's something that we see that people aren't aware of, that requirement that it has to be cash. The game has to be conducted in a fair and honest manner. There are some restrictions on where gambling can be conducted, and I'm not going to cover that in detail today. Merchandise cannot be repurchased, and cash prizes have to be distributed the same day that they're won. In addition, no prize can be displayed that cannot be won. And then at least 75% of the net receipts must be dedicated for educational, civic, public, charitable, patriotic, or religious uses. There are also withholding taxes required for prizes over $600, and sales taxes on gross receipts of the gambling activity are required, except for governmental agencies. And finally, there are annual reports required for all charitable gaming, and the time period that's covered is July 1st to June 2nd. So the gambling receipts, less expenses, taxes, and prizes must be distributed as required to charitable, religious, civic, public, or patriotic uses by July 30th, which is 30 days following the end of the annual reporting period of June 30th. So those are kind of the basics of charitable gaming. And now I'm going to turn it over to Stacy to talk about social gaming.
Good afternoon, everybody. Deborah said my name is Stacy Hull, and I'm going to talk to you about social gaming. And you're going to see as we go through these statutes, and as Deborah said earlier, this is just an overview. The social gaming statute, the charitable gaming statutes are very complicated, and we could spend a lot more time on it than we are today. But basically what you're going to see with the social gaming statutes is that they are designed to keep this to be social gaming between individuals who are in the physical presence of each other. If anyone's making money off the gaming, other than the people that are participating in it, or if they're gambling, it's not low-stakes gambling, then it's not going to be social gaming. It's not going to be meeting the requirements of the statute, and it's going to be illegal gaming. So you're going to see the social gaming kind of divides what's allowed and what's not allowed by whether your gaming is taking place in public premises or private premises. And if you're in a public premise, you're going to need a license to permit individuals to gamble in your premises. So the distinctions between public places that have a liquor license and those who don't have a liquor license. If you are a public premise that does not have a liquor license, you're going to need to get a social gaming license from the Department of Inspection and Appeals. It's a 2-year license, and it allows gambling between individuals of any age to take place on the premises. There has to be a bona fide social relationship between the people in the establishment, and they have to be there for reasons other than gambling. So, you know, I don't know that I've ever gotten a question from somebody that has this type of license, but what I would imagine the establishments that have this type of license would be a coffee shop or some sort of other public place without a liquor license that people come together to hang out. Maybe a restaurant without a liquor license. As a license holder, the license allows you to permit individual gambling to take place. The license holder cannot sponsor, they can't conduct, and they can't promote any of the games that are taking place in their establishment. But they can participate on the same basis as anybody else that's participating. Here's the low stakes. No more than $50 can be won or lost by any person participating in the social gaming over any 24-hour period. And again, the owner of the premises cannot be making money on the gambling, so you cannot charge a cover charge anybody for the privilege of participating or observing the social gambling that's going on in the premises. And there are certain games that are permissible and other games that are not. Your permissible card games include poker, pitch, gin rummy, bridge, euchre, hearts, and other parlor games, cribbage, dominoes, checkers, backgammon, darts, pool. And more or less your impermissible games are going to be those ones that you would find in a casino. Poker tournaments, it's only the tournaments that are not permitted under a social gaming license. You can have individual games, but there are no poker tournaments. Casino games for which the house provides a banker-dealer, such as 21, baccarat, that sort of thing, other than poker. You cannot have punch boards. You basically cannot use gambling, or people in your establishment cannot use gambling implements, punch boards, push cards, pull tabs, slot machines, craps, etc. No specially marked tables. And a public place, the social gaming license at a non-liquor licensed establishment, it does not allow for sports betting pools to be conducted on those premises. Only premises with liquor license can conduct sports betting pools, and there's very specific requirements for how to conduct a sports betting pool, and we're going to talk about that in a few minutes. So if you are a public place that has a Class A, B, C, D liquor license or a Class B beer permit, you may also apply for a license to allow individuals to engage in social gambling on your premises. It's another 2-year license. I believe it's a little bit more expensive than the license for a non-liquor license holding establishment. It's $150 if my recollection is correct, and $100 for a premise without a liquor license. Like those premises that don't have a liquor license, the people that are gathering to engage in social gambling must have a bona fide social relationship and have to be in the establishment for reasons other than gambling, and they also have to be 21 or older to engage in social gambling at a liquor license premise. That's not a requirement in premises that do not have a liquor license. It can be persons of any age. There's no requirement that the participants be even 18 or older at non-liquor license establishments. Again, the license holder cannot sponsor, conduct, or promote any game, but they can participate on an equal basis as any other participant. Again, no more than $50 won or lost in any 24-hour period other than sports betting pools, and we'll talk about that in a moment. And again, you cannot charge anyone for participating or observing the gambling that's going on in your establishment. The permissible games are the same as those that are allowed in establishments without liquor licenses. And in addition, premises with a liquor license and a social gaming license can allow sports betting pools to occur on their premises. And your impermissible games, they're same as those non-liquor licensed establishments. No casino games, no house banks games, other than individual poker games. And liquor licenses conducts sports betting pools. So there are pretty steep penalties against a liquor license who allows gaming in violation of the social gaming statute. There's penalties against your liquor license for a violation, including a $1,000 fine, and I believe that's probably for each occurrence, and I'm not sure how the AG's office would tally that up, but I'm sure it would be as steep as they possibly could get it. And also, you're facing a 21-day suspension of your liquor license. So let's talk about the strange world of sports betting pools. First of all, you have to have a liquor license or a beer permit and your 2-year social gambling license. All your participants have to be 21 years or older. Now, in this case, rather than your max wager being $50, your max wager is $5. And your max winnings are not $50, but your max winnings are $500 per pool. And all of the money that's wagered, put in, must be put back out. So it's truly a pool. No one retains any of this. Everything that goes in has to come out. Now, what I find to be kind of an odd requirement is that the sports betting pool has to be conducted on a grid. And before we move on to the next slide, you also can't charge someone to participate or observe the sports betting pool. So when the requirement that it has to be conducted on a grid, which means a vertical line that has numbers and a horizontal line that has numbers, and then there's squares that correspond to a horizontal and vertical number. People can buy a square or numerous squares. It's up to the person that's setting the rule, but this is how it has to be conducted. So you will need something that looks like this. I encourage you in your outline material that you got, not on the slide, there is a link or a site to a very thorough guide that the Division of Inspection and Appeals has put out. If you have a client that is interested in allowing sports betting pools to be conducted on its premises, the example that they give is of a NASCAR sports betting pool where the vertical line represents the starting position of cars and the horizontal line represents the end position of the cars. So first people would pick will buy however many boxes they wanted to buy, and then you would figure out how much you can charge per square as to how many boxes you have on your grid. And that's a maximum you can charge, and no one can spend more than $5 on all of their squares in that one pool. And sports betting pools also have to be based on one particular athletic event. It can't be based on numerous athletic events. So that's one example. I encourage you to go and look at the guidance that the DIA has put out. It's very thorough and helps clear up a lot of the confusion on how to conduct sports betting pools. Now, NCAA basketball tournament. It is not permitted in beer and liquor establishments. Beer and liquor establishment cannot allow NCAA bracket basketball tournament betting to go on in the establishment. And that's because of that requirement I just talked about, is that the sports betting pool has to be based on one athletic event only. So you cannot have it based on a tournament. But you can have betting pools allowed for individual games. So, for example, you might have a smaller grid with the predicted score at the end of a particular half or quarter. It would be something that you would be able to do in an individual game. And if you want to allow betting on individual basketball tournaments in a beer liquor establishment, you have to have that 2-year license. Okay, so in other locations, and by other locations, we're now talking about private establishments, because the persons with the public premises without a liquor license are not allowed to conduct sports betting pools. So we're talking basically about your office pools going on between individuals or pools among friends. And we're going to talk about the requirements for gaming social gambling between individuals at the end of the presentation here. So basically, NCAA basketball tournaments, can you do them at your office? Yes. Here are the rules. No participant wins or loses more than $50 in a 24-hour period. And when I get questions about office pools, and I usually do in March, this is the thing that I see that trips up people most often, is that people are winning more than $50 in a 24-hour period because the pool's getting so big that at the end, when you've got your winner, the pool's much more than $50. So my advice to these people is either to break it down into smaller groups, subsets, so no one's winning more than $50 if you want to have one award at the end of the tournament, or to have more types of prizes, award the leader at certain stages in the tournament. That's another way that you can deal with that $50 win limitation. Another problem that I see is all your participants have to be individuals. So each person has to fill out and turn in their own brackets. You cannot turn in a bracket for somebody else. If you do, you are engaging in bookmaking, which is a very bad thing to be doing. There's no minimum age for NCAA basketball tournaments, but all of the persons involved in them have to have a bona fide social relationship. The NCAA tournament has to be conducted in a fair and honest manner, and no one can receive a profit from a basketball tournament other than through participating and winning in the tournament. I sometimes get questions where people want to do an NCAA basketball tournament and then turn over the proceeds to a charitable organization. And Deborah's over here frowning. Yeah, I'm sure that whatever charitable organization does not want to receive your illegal gambling proceeds. Okay, so another thing that is contained in 99B is bona fide contests. And if you are running a bona fide contest, unlike when you're allowing social gambling to occur on your premises, you can charge an entrance fee and you can award prizes. And you do not need a license to do it. But there are only certain types of contests where you're allowed to do this. And we've got them listed here. Athletic and sporting contests, leagues, tournaments, rodeos, horse shows, golf, bowling, trap or skeet shoots, fly casting, tractor pulling, rifle, pistol, musket, muzzle loader, pool darts, archery, horseshoe contests, leagues, or tournaments. Races, also your contests you'd see at like a fair. You've got your exhibitions of cooking, biggest pumpkin, prize-winning pumpkin, livestock, poultry, fish, or other animals, artwork, hobbywork, or craftwork, except for those prohibited by Chapter 1770A. And if you want to know what's in there, you're going to have to go read it. Cribbage, bridge, chess, checkers, dominoes, and similar contests, leagues, or tournaments, except for, guess what, poker tournaments. No poker tournaments. And also video machine golf tournament games, Golden Tee. I know some bar owners got that added to the list of contests several years back when that was a popular thing to do in bars. And last year there was some legislation by some large groups, I will say, to attempt to add fantasy sports to the list of contests. I imagine we're going to see that legislation again this coming year, but I think we got a question the last time we did this webinar as to whether fantasy sports betting was allowed, permitted under this. And I would say individuals, among individuals, between individuals, and we'll talk about that, who are in the physical presence of one another, it would be allowed, but it can't be done on the internet, and nobody can profit off of it. So a bunch of buddies that got together and have their own little fantasy sports league could bet on it, but nobody can be making money off of it, unless, of course, it gets added to the list of contests that are permitted under 99B. So as we talked about, poker, blackjack, craps, keno, roulette, not permitted as bona fide contests. Now, individuals in the physical presence of one another may wager on these contests. So, and they can wager on certain some other things that we're going to talk about in a few minutes here. But notice the requirement of being in the physical presence of one another. You can't do it on the internet. So, social gaming between individuals. These are things that would typically occur. Some of these things could occur in a public premise that has a social gambling license. And some of these things could only occur in private because they're not permitted at establishments with social gaming licenses. So individuals with a bona fide social relationship, which means they know each other before they have a relationship, before they come together to wager with one another. They can wager on card and parlor games. So yes, it's perfectly legal to host your poker night in your basement, and people can lose or win up to $50 at your poker night. Or gin, bridge, card games, other card games, pool, darts, chess, etc. Individuals in the physical presence of one another can also wager on other games of skill or chance, or those contests that we just talked about, those bona fide contests, or any other event or outcome that doesn't depend on illegal gambling or the use of a gambling device. So you and your buddy could have placed sitting there watching the election results come in a couple weeks ago could make wagers on whether Republicans were going to win this state or that state. That's allowed. You cannot make wagers with each other using a roulette wheel or a craps table. That's not allowed between individuals even. And here's a list of other things. You cannot engage in bookmaking, and we talked about that definition of bookmaking. So if you're receiving bets from somebody that's not in your physical presence or someone that you don't have a prior relationship with, you may be engaging in bookmaking. And here is 99B contains a definition of bookmaking. It's 99. It's in 99B1, and it means the taking or receiving of any bet or wager upon the result of any trial or contest of skill, speed, power, or endurance of human, beast, fowl, or motor vehicle, which is not a wager or bet placed pursuant to Section 99B12, which is the section that allows this gaming between individuals, or which is laid off, placed, given, received, or taken by an individual who was not present when the wager or bet was undertaken, or by any publicly or privately owned enterprise where such wagers or bets may be undertaken. So you can't have a business of taking bets, and you can't take bets from somebody who's not in your physical presence. You will be engaging in bookmaking under 99B. And if you're making money off of it, you're going to be engaged in bookmaking under Chapter 725, which is the vice statute. So the other things you cannot do is you can't use punch boards, push cards, pull tabs, slot machines, craps, chuck-a-luck, roulette, Klondike, blackjack, no blackjack, even in your private residence, no betting on it at least, baccarat, faro, equality, three-card Monte, or any other game except poker, which is customarily played in casinos. So other than poker night with your buddies, no casino games going on between individuals. Okay. Also, there's a portion of 99B that talks about, oh, I think I just blew by a slide here. Okay. So here's the other requirements of gaming between individuals. You cannot wager or win more than $50 in 24 hours. And like I said, usually it's the problem of not winning more than $50 in a 24-hour period, not losing more than $50 in a 24-hour period. You can't place wagers for anybody else. You can't wager on an athletic event if you are a coach, official, player, or contestant in that athletic event. And again, you can't charge your buddies a cover fee, and you can't keep part of the pool, or you can't keep part of what was wagered. You can't, and nobody else can. Again, the point of the social gambling statute is to make sure no one's making money off of it. Company games. Games of skill, chance, and card games, including casino games, may be conducted without a license if there is a bona fide social, employment, trade, or professional association relationship between the sponsors of the game night and the participants, and the participants pay no direct or indirect consideration. So they can't charge, again, you can't charge a cover, you can't charge anything for whatever you're using to conduct the company games. And the sponsor receives no consideration other than just the goodwill of letting these good people have some fun. You can only use play money or items of no intrinsic value are used to wager and are provided free. And you can use gambling devices. So in a company game night, you can have a roulette wheel, you can have a craps table, you can have blackjack. You just can't make any money off of it. Enforcement. The Division of Criminal Investigation can investigate to determine compliance with with all provisions of 99B. So charitable gaming and social gaming. They can do this on their own initiative or at the request of the Division of Inspections and Appeals. Now, if you are unlucky enough to have the DCI investigate this, and you're charged with violating the chapter, you're going to be prosecuted either by an attorney general or a county attorney. And correct me if I'm wrong, Deb, but I don't think there's any actual penalties written into 99B. As far as a civil penalty, probably what you would be charged with would be illegal gambling. Yeah, it would be a criminal charge too. So the consequences of violating these statutes can be very serious. Does anyone have any questions?
Christy will now open the phone for questions. These are the instructions.
If you have a question at this time, you can type it in your chat box and the speaker will see it. Right now we don't have any questions. Susan, did you have any questions?
I did. On the company gaming night, you have play money, but can you redeem the play money for prizes? I mean, what's the point?
Yes.
You can.
Yes. You can. The company can award prizes.
Yeah, if they were donated, yeah.
If you have a question at this time, you can type it into the chat box.
While we're waiting for that, I'd like to again repeat the activity number for this CLE, which is 160776. And also bring to your attention that we have an upcoming CLE on December 10th near the holidays and holiday activities. It's called It's Your Burden, Top 10 Tips for DOT, which is the Department of Transportation, Administrative Hearings. The CLE will provide practical tips and basic information for handling an administrative IDOT driver's license revocation or suspension hearing. The burden of proof and relaxed rules of evidence make these administrative hearings very different from the corresponding criminal OWI proceeding. The presenters include an Assistant Attorney General who represents the Department of Transportation in administrative hearings and appeals from those decisions, a defense attorney who represents individuals appealing their driver's license revocations or suspensions, and an ALJ who provides over DOT hearings and issued decisions. Any questions? Yep. There is a question, so I'll.
Let's see. Is there any maximum limit to the size of grid used when making sport pool bets?
No, there is not. You just can't have. I guess I would say that yes, the maximum amount would be, you can think the lowest amount you can charge would be probably at 1 cent per square. So you wouldn't be able to have more than 5,000 squares.
Because the maximum
that you can win is that can be won is $500.
and the maximum that can be wagered is
$5.
Let's see. If a merchant wants to donate goods, say a $500 value to a charity to raffle off, it would seem that the charity needs the license to handle this raffle. If the charity has a license, many of the stores donating the prizes display prizes and selling tickets, or does this have to be done at the charity and not advertised at the store?
Is this as in a raffle, if you're raffling it
A
off?
raffle, if you're raffling it off.
Well, I mean, I can say what I would advise if a business was coming to me, it would be that it's the charity that has to conduct the raffle and sell the raffle tickets. Can you allow them to be purchased from the charity at your place of business? I would say probably if you have someone that is a member of that charitable organization that is an employee of your business or is present at your business when those raffle tickets are being sold.
Yeah, I would agree with that. And I don't see any problem with displaying the prize there at the business during that promotional period of the raffle. Then, of course, at the actual raffle, you'd have to have the prize displayed at the event.
So could a bar owner use 2 squares on a grid and make it into a straight up bet on a particular game?
Two, I don't see how, well, I don't see how you would have a two square grid. You could have a 4 square grid and make it a bet on a game. But
at that point, you're betting on
the athletic contest.
Yeah.
So the answer to that particular question would be no.
That was the one we did. Okay, that looks like the last questions. Do we have any other? If you have any more questions this time, you can type them in. Any final comments or cautionary things?
I have one comment. I think if you do have a question on something, can you call the Department of Inspections and Appeals? Or
Yes, and in this last slide here, I have the contact information for Dan Horner. He's kind of the program person for our social and charitable gaming. He's very knowledgeable and can answer questions. I have my contact information there as well, so feel free to contact either one of us with any questions that you have. And as far as questions about what type of license, what the activity is, those type of things, we're happy to answer those questions at any time.
best to ask those questions in advance.
Yes.
I guess my comment would be, as a person who advises charities and businesses, is that often if you're involved with the charity, you need to kind of keep an eye out. Lots of charities, I think, don't realize that once they are proposing to do something that involves an element of chance, that they're going to need a charitable gaming license. An example that I can think of with a charitable organization of which I'm a board member is we have a gala, a function, annual function, and our activities that typically involves a auction. And they proposed to do a grab bag where people would pay $5 and pick out a bag and not know what was in it. And they needed to get a charitable gaming license for that activity. So that's something to keep an eye out if you are advising nonprofits.